Ms. Vest, will you please call the roll?
Thank you, Madam Chair. Let me first make the statement that we are running just maybe about 15 minutes late due to the weather. Scott Cockcroft.
Here.
Keith Harvey. Vivian Hickson.
Here.
Karen Jones. Mackenzie Roberts.
Here.
Let the record show that Keith Harvey and Karen Jones are not present, but you do have a quorum, Madam Chair.
Okay, thank you. Have the members had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
Make a motion to adopt the agenda as it was presented.
Second.
The second time.
He could have gone all day without that, couldn't he? Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft, or vice versa, to adopt today's agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. And have y'all had an opportunity to review the minutes from the April 20th meeting?
I have. There were two corrections that I found. If we can refer to those, page 33, line 5, the word hoop should be hoops. That's plural.
HOOPS.
That's correct. And on page 111, line 23, it reads currently that, decided that and agreed citation is not enough. It should be decided that and agreed. It should one word instead of two. Page 111, line 23. Those were the two errors that I found that needed correction.
Agreed.
Yes.
All right. Well, so,
We agree on that.
yes, sir, we agree.
With those changes?
Unless there were some other corrections or changes, I would make a motion that those, that our minutes from that meeting with the two corrections I have indicated be approved.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to approve the minutes from the April 20th meeting with the two corrections on the record. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Okay, Ms. Thomas, it's your time to shine.
For the legal report, I'm just going to defer to our disciplinary counsel, Ms. Lindsay Shepard.
Hi there.
Good morning.
Good morning.
Excuse me, Ms. Shepard, before you get started, we do have a new court reporter with us this morning, so we do want to make sure that we do take our time, and if you should have any questions, please stop us. We'll be glad to assist you.
Yell real loud.
All right. For case number 1, that is case number 2017-003101. This case arises out of an industry complaint alleging multiple violations. Complainant is respondent's former QA, whose employment was terminated. Complainant filed an almost identical complaint last year. The board dismissed the previous complaint with no action. Complainant alleges respondent currently advertises CCTV work despite being unlicensed. Respondent has been certified in CCTV since January 23, 2017. Complainant alleges respondent is operating under a different name from license. Respondent properly registered that name with the board as a DBA over a year ago. Furthermore, respondent's DBA name is the name of respondent's properly licensed parent company. Respondent is a wholly owned subsidiary of that parent company. Complainant alleges respondent does not properly secure records and allows access to unregistered employees. Respondent denies this allegation. Respondent claims that all their records that may be of sensitive nature are kept in metal cabinets with block walls and a locked door. Only authorized personnel have access to this room. Complainant specifically names 2 people and claims that they do service, sales, and installs while unregistered. One of those employees was in fact registered. The other named employee formerly managed new business development for respondent's parent company. He is now retired. My recommendation is to close.
I'd make a motion that we agree with the recommendations from our council.
Second.
Okay, we have a motion by Mr. Cockcroft and a second by Mr. Roberts to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2 is 2017-021511. This case arises out of a consumer complaint alleging unlicensed activity. Specifically, complainant alleges that respondent installed cameras at his church and at a city hall building. Complainant was unable to provide proof or documentation. Respondent is a limited licensed electrician, otherwise known as an LLE, who installs IP cameras. Respondent claims that IP cameras are less than 6% of his business. He believes that he is exempt from alarm system licensure pursuant to Tennessee Code Annotated 62-32-3057, which exempts licensed electrical contractors who derive less than 50% of their business from alarm systems. Limited licensed electricians are not considered electrical contractors and are thus not exempt from alarm system licensure. However, respondents stated that they would be glad to get the proper license if needed. My recommendation is formal charges authorized with authority to settle with a $1,000 civil penalty for violation of Tennessee Code Annotated 62-32-320B, which is unlicensed activity. In lieu of a civil penalty, allow dismissal with a letter of warning if respondent obtains a CCTV license within 6 months. Also allow waiver of 6-month license ineligibility for unlicensed contracting under Tennessee Code Annotated 62-6-320B, which I have copied below for your reference.
How can a electrician get a CCTV license?
Well, an electrical contractor can be exempt if they file the exemption, but it sounds like this isn't.
Yeah, but he can't get a CCTV license, though, can he?
He could apply for it, and I mean anyone could exceed what they have to do, but it doesn't sound like he's an licensed electrician. Is this like a license for low voltage or something?
So what this is, I've got the contractors board too. It is so the way the statute is written, the exemption is written is it says if you're an electrician licensed under Title 62, I believe it's Chapter 6, but I'd have to double check. It's the contractors chapter.
A specific license that they don't have.
Well, it's a specific, so basically if you're an electrician licensed by the Tennessee Board for Licensing Contractors. So this a limited licensed electrician is licensed by the Board for Licensing Contractors. However, it also says you need to be an electrical contractor, which an LLE is not technically an electrical contractor. LLEs can do electrical work as long as the total is under $25,000.
They can actually do like high voltage electric. They could install lights, and they can.
Yes, that's correct, they can.
What's your feeling on that? Do you feel like that?
This respondent would not fall under the exemption, would not be qualified for it, clearly, as our legal counsel has advised.
That would be my first inclination. I just want to make sure that we're complying with what the law says.
I would agree with the recommendation of our counsel. However, I would also need the stipulation that he not engage in the business of installing CCTV devices, cameras, such, until he receives his license. The idea of a $1,000 civil penalty is appropriate, in line with our guidelines. It allowing this certainly appears to be a case where someone was honestly believed that he was exempt, allowing him 6 months to become licensed. Frankly, to me, is not in accordance with the statute, but would probably make good sense and be fair to all concerned. But we certainly must have a stipulation that he would refrain from doing any CCTV installation work until he received a proper license. You know, I can make that into a motion if you would like.
Could I throw in a few things there? The one problem I would have of not having some sort of civil penalty, we do want them to get licensed. I don't have a problem with waiving the 6 month so that they can go ahead and get licensed. But I don't think that we should let someone go until they get caught, and then, because he would have had expenses. If he'd been licensed, he would have, for a couple of years, he'd have spent $1,000 anyway. So if someone goes and they can just operate unlicensed and then get their license when they get caught. My other question is, did he ever file that exemption? Because you have to file that exemption if you actually expect to have been covered under that.
No, sir, he didn't qualify, but he did not.
So he didn't try to file
no.
either. So I don't think it was necessarily thinking that he was covered under that until after the fact. That's just my opinion, I guess. But I would think there should be a penalty. I'd like to see him get licensed, not prevent him from going forward further.
I will say, so we can't force him to get licensed.
Right.
So the reason why I had waiving the civil penalty, if he does get licensed within 6 months, is that's an incentive to do so, because our ultimate goal is compliance.
Right. I think there ought to be a civil penalty, but we allow them to get licensed because they want to continue. I would assume they want to continue to do that business. They probably want to service those customers they've already put in. Their incentive for getting licensed is to not have another fine later or another civil penalty.
I would agree with Scott. Let me put this in the form of a motion.
Okay.
That we authorize formal charges, the authority to settle for a $1,000 civil penalty, that we waive the 6 month license ineligibility so that he could then go begin and continue the process of getting the appropriate license.
That in lieu of civil sentence, starting with in lieu of civil penalty, I think that gets what you want.
Be fine.
All right.
I'll second that.
Okay, we have a motion to agree with our council's recommendation in this matter with the deletion in lieu of civil penalty
Whole sentence.
to allow dismissal with a letter of warning if respondent obtains a CCTV license within 6 months.
That would be deleted.
That entire sentence would be deleted, but the rest of council's recommendation is y'all's motion to approve. Correct?
Yes.
Correct.
All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Okay, let me make sure I've got it right for myself. The civil penalty is $1,000.
That's correct.
We're telling the gentleman he does need, the company, that they do need to get a license.
Right.
And we're going to waive the statute that says he has to wait 6 months due to having a complaint.
That would be correct.
All right, thank you.
Could he may also, I guess, have a concern with experience. If he had, I would think we should accept his current experience if he
But
has.
that's going to be a different
That's gonna-
matter.
yeah.
Okay.
Because
You have to go through the
if need be, I'll have
process.
to bring that to the board based on
Okay.
his experience. The individuals. This is just telling the company they can make application, and we're going to waive that 6 month waiting period.
They might even have a QA that already
There you go.
was licensed. Okay.
Case number 3 is 2017-024261. This case arises out of a consumer complaint alleging failure to adequately monitor. Complainant alleges that money and important papers went missing from her home approximately 1 month after her alarm system was installed. Complainant believes that her alarm system should have prevented the theft. Complainant suspects that the installing technician may be responsible for the thefts. In response to the complaint, respondent states that complainant's account was sold and installed by a licensed third party. As such, all aspects of the sales transaction and system installation took place directly between the third party and the complainant. Respondent has contacted complainant in an attempt to resolve her concerns. Complainant refused to allow respondent to test the system over the phone. Complainant did allow respondent to send out a technician. Respondent claims the technician spent over 2 hours testing the system and explaining to complainant how to use it. The technician determined that the system was functioning properly. My recommendation is to close.
Madam Chairman, I make a motion to concur with the recommendation of our council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 4 is 2017-024651. This case arises out of an industry complaint alleging respondent is mailing marketing material without providing the company license number. Complainant did not provide supporting documents. Respondent is a multi-state alarm system company. Respondent admitted to the mistake and stated that the oversight had been addressed by the owner and QA with their marketing team. Respondent states that it will include its license number on all future marketing materials. My recommendation is considering respondent's cooperation with the board and affirmative action by the owner and QA to prevent future missteps, council recommends a letter of warning for TCA 62-32-316D, stating that all alarm system contractors shall permanently display their certification number on all advertising, service vehicles, correspondence, business cards, letterheads, and the like.
I make a motion to concur with the recommendations from council.
Second.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Roberts to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 5 is 2017-020591. This case arises out of a consumer complaint alleging unethical business practices. Respondent is a licensed alarm system electronics supplier. Respondent acts as an authorized dealer for a licensed alarm monitoring company, hereinafter referred to as monitoring company. Complainant signed a 60-month alarm installation and monitoring contract with the respondent's sales representative in March 2015. Although the sales representative was a registered employee of respondent, the actual contract was between complainant and a third-party monitoring company. Complainant alleges that in March 2015, respondent's sales representative solicited her business by claiming respondent would pay any remaining costs associated with her previous alarm system carrier. The quality assurance questionnaire filled out at time of contracting indicates that complainant was only promised 1 month free as an incentive. However, complainant claims the sales representative handwrote the incentive description after she signed the questionnaire. The sales representative was previously registered with the board as respondent's employee. The sales rep switched his registration to a different alarm company in September 2016. Complainant timely paid her bill to the alarm monitoring company May through December 2015. All bills came from the monitoring company and payments were made directly to the monitoring company. Complainant then received a final invoice from a previous alarm system company. Respondent's sales representative refused to pay that balance. Complainant then requested that the monitoring company cancel her account. Complainant received confirmation of the contract cancellation on January 12, 2016. Respondent then sent the entire 60-month alarm monitoring contract amount to collections. Complainant alleges that respondent's employee misrepresented the identity of his employer. Complainant believed that the sales representative was indirectly employed by the monitoring company. Respondent denies this allegation. Respondent claims there was no misrepresentation because respondent is an authorized dealer for the monitoring company. However, complainant's confusion is justifiable. The actual contract negotiated by respondent's employee is between complainant and the monitoring company. The copy of the contract submitted by respondent is conspicuously missing the top left corner. it could be implied that respondent intentionally hid that corner from the board. Complainant submitted an unredacted copy in her rebuttal showing that the missing corner showed the monitoring company's name and logo. The only paperwork given to complainant stating respondent's name was the quality assurance questionnaire. The questionnaire had respondent's insignia in the top right corner. However, there's nothing in the text of the questionnaire indicating that the sales representative worked for respondent. The questionnaire does not include respondent's license number. Complainant received confirmation of account cancellation in January 2016 from the monitoring company. Respondent then sent the total amount of the 60-month contract to a collection agency. Complainant never had a contract with the respondent. And even if the contract were with the respondent, the amount respondent sent to collections exceeded the contract balance. As a note, I have written, the sales representative's conduct would constitute multiple violations of Tennessee Comprehensive Rules and Regulations, Chapter 9-6, which establishes the standards of conduct for door-to-door solicitation and contracting with customers. However, that rule did not become effective until after complainant already canceled her account. As such, those violations are inapplicable. My recommendation is a $4,500 civil penalty with formal charges authorized for violations of the following. Tennessee Code Annotated 62-32-316D, stating that all alarm system contractors shall permanently display their certification number on all advertising, service vehicles, correspondence, business cards, letterheads, and the like. Tennessee Code Annotated 62-32-316E, stating no certified company shall engage in any business regulated by this part under a name other than the certification name or names that appear on the certificate issued by the board. And Tennessee Code Annotated 62-32-319D, which allows disciplinary action for conduct that constitutes improper, fraudulent, or dishonest dealing.
Elaborate a little bit on the respondents, the first contact, I guess, with the complainant. Was that with one company and then later a different company? I got lost in there somewhere, I think.
Right, this is a confusing fact pattern. So respondent sales rep negotiates a contract with complainant, the 60-month monitoring contract, that respondent isn't even a party to. So like the contract that complainant signed with respondent sales rep is actually between complainant and the monitoring company.
Respondent tried to collect the entire 60 months.
Even though they aren't a party to that contract.
Like the monitoring company tried to turn it over to collections or collect, and I guess they weren't successful, and then they gave it back to respondent.
That's what's unusual about this. It's actually, monitoring company didn't turn this over to collections. It's the respondent who wasn't even.
The installing company.
Took it back, and when it got kicked back to them.
Yeah, that's what happened.
So, but the respondent didn't have they only dealt with the customer one time. I mean, it was like at first it sounded like they were the original company, and then they tried to sign them up with somebody else. But
so she had, when complainant sales rep contacted her, I'm not sure whether it was via phone or in person, she already had a alarm system installed with someone that isn't even involved in any of this. And respondent sales rep said, tell you what, sign up with me and we'll pay off any money that you owe to your old alarm company. Old alarm company sent her a bill. Respondent said, oh, no, I never told you that. Refused to pay off that outstanding bill. So then the complainant cancels her contract with the monitoring company that she signed with respondent's sales rep.
I think you described it very well.
yes. I definitely think there needs to be a penalty. I guess my concern is if that's too high. Here we have someone that is licensed. They're doing, it sounds somewhat unethical. It does sound, not somewhat, it sounds unethical if that all transpired. And then we had somebody that was completely unlicensed. They were less, but I guess that was more, it wasn't necessarily as unethical.
This company has a pretty significant history too, if you'll.
Of similar, okay. What are your thoughts, Ken?
Well, I would agree with your comments that I think the formal charges and civil penalty against the respondent, and I'm going to refer to them as the installing company, is certainly appropriate. It would appear to me that the behavior of their agent or sales representative, whatever his particular title might be, was quite inappropriate. I am just wondering about the involvement of the monitoring company. Since the contract was signed between the complainant and the monitoring company, then I wonder if we would not be in a position where the sales representative should, acting on behalf of the monitoring company, having the monitoring company's contract signed by the complainant, was not, even though they were not an employee of the monitoring company, were acting as an agent of the monitoring company. Now, I don't know about the legality of that, but it certainly would seem to me that if the sales representative came forward with a contract to be signed with a monitoring company, that they're not acting as an agent of that monitoring company.
The respondent company is an authorized dealer of the monitoring company.
I understand, but if the contract was between the complainant and the monitoring company, then it would appear to me that the sales representative was acting as an agent of the monitoring company.
I kind of looked at it more as like doing business in a name that isn't yours, which is why I cited the shall engage in any business under a name other than the certification name or names that appear.
I think it's appropriate on behalf of the respondent.
Right.
But like I say, I am wondering if we should consider the sales representative's actions as being a representative of the monitoring company.
I don't have anything in the file showing that the monitoring company encouraged this or was even aware of this.
And it's also fairly standard in the industry for, paperwork for a monitoring company that they may consistently sell contracts to. And I think that's fairly normal. And I don't see necessarily the collusion on the part of the monitoring company, because when they found out about it, it sounds like they canceled it. They didn't pursue her in collections. I don't see where they may have participated, but I don't think they were active in doing anything wrong there. Maybe if it continued, if it was an ongoing thing where it happened over and over.
I think your concern was more with the salesperson than the monitoring company was.
Well, let's do this. I think we probably have an agreement that civil penalty, authorizing formal charges with an offered civil penalty to the respondent, which would, again, the installing company, would certainly be appropriate. Their behavior in this matter seems reprehensible. The sales representative, as well as probably the company that they were directly employed by. I would really be interested in getting some sort of a legal opinion as to the involvement of the monitoring company being represented by an agent in the circumstances like we've outlined here. Maybe we don't want to pursue that right at this point, but I'd be interested in finding out if the circumstances that we have here, where you have a sales representative from the respondent company bringing forward a contract to be signed with a third party, which in this case would be the monitoring company. So let me do this. Let's make a motion that we concur with the recommendation of our counsel. I think the authorizing formal charges with a proposed civil penalty is appropriate, but like I say, I would really be interested in seeing if we could get an opinion, a legal opinion of what culpability the monitoring company might have in this situation where the sales representative was presenting a contract on behalf of the monitoring company to be signed with the complainant here. So I made a motion for formal charges and the civil penalty as recommended by counsel.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Cases number 6 and 7 are 2017-029891 and 2017-026141. This case arises out of an industry complaint alleging respondent is allowing an unlicensed LLC to do business under respondent's license number. Complainant, an industry competitor, provided documents showing that the unlicensed LLC has submitted quotes using respondent's license number. Respondent claims that the unlicensed LLC acts as a, quote, engineering/research and development arm of their company. Respondent's sole owner owns 99% of the LLC. The LLC and respondent, or corporation, are registered with the Tennessee Secretary of State as separate entities, but they have the same office address. The LLC's website also redirects to respondent's website. The chief financial officer of both the respondent, corporation, and the LLC claims that the companies were only organized as separate legal entities for tax purposes. Since receiving the complaint, respondent has registered the LLC with the board as a DBA name. However, the LLC is still a distinct legal entity from respondent. As such, the LLC may not perform services requiring an alarm system license. The company's CFO expressed willingness to make change in order to get in compliance. Considering respondent's honesty, prompt response to all communication, and willingness to achieve compliance, counsel recommends a letter of warning stating that all activity requiring licensure must be performed by the licensed entity.
Why didn't you bring us some simple cases instead of...
There was one earlier, I think one of them was real simple. The licensed company is licensed in good standing, no problems there. Are all of the employees registered? I mean, are there employees of all the LLCs registered under the licensed company?
I don't for sure know that answer to that, but when I spoke to their CFO, he said that the companies had different roles and different needs for expertise. So I would think that they are not.
Because if an employee of the unlicensed LLC was out doing work, submitting a bid, that employee would need to be registered. I guess I'd feel better if all the employees were registered with that company. I'd feel like, well, they were making an effort to comply. But if you've got employees in the unlicensed company that aren't registered, only employees of the registered company are registered. You follow what I'm saying?
Right.
That would sound like that would be different. I guess we might need to know some more information on that. Do you see where I'm going with that, Ken?
They did get, so I think that the licensee thought when they received this complaint that the issue is that they were doing business under a different name. So they registered, once receiving the complaint, they registered that LLC as a DBA. And they thought, well, so I've taken care of that problem. So I talked to lawyers in my office who are above me, a couple of them actually, because this is more of a business organizations issue than a licensing issue, which is why I think a letter of warning and explaining to them, like, you can't do business. Unlicensed LLC can't do business that requires a license.
I think I'm confused if the same person owns 99% of both, why he would even run those types of quotes through the LLC.
He probably shouldn't have.
That's why I'm wondering why they did it.
Again, he may have tax reasons. There may be liability reasons why there's more than one legal entity. So that, in a sense, makes sense. I think probably, as you've outlined, the response of the respondent and the communications and their apparent willingness to be a compliant company, that weighs heavily with me. I do think it's important that we outline, or in a letter of warning, and I'm going to make a motion for a letter of warning. But I think we do need to give them a clear understanding of what they should be doing and what they should not be doing, and they should not be doing business as in an unlicensed company's name with a licensed company's registration number. If they're going to be doing alarm business, then they need to really be doing it in the name of the land, in the legal sense of the licensed company. But I would make a motion that we concur with the recommendation council. We give them a letter of warning and give them some clear instructions as to what they should be doing, what they should not be doing, so that they can come into full compliance.
Can we talk about that for just a second? Do we have I guess we have the option, but could you go back to them and request more information, such as requesting documentation, whether that be 941 reports of who their employees are, and verify that those employees, or that if any employee of the unlicensed company is registered with the board?
I could, but for all intents and purposes, let's assume that they don't have the same employees. Would that change?
In my mind, that would change, because if there's and maybe that should be a separate complaint, but there's unlicensed employees, and it would suggest that there was more of a joint venture to circumvent the law, and that's something specific in there, that you can't have a joint venture to circumvent the law. You can't say, well, these two LLCs are going to work together,
Right.
and we're working together, so this one doesn't have to be licensed. If they're truly, if it's an honest mistake and it's all the same employees, and maybe they have two different company names because one does alarms and one does cameras, and they market them as different names, but it's really all one big happy family, I'm fine with what you proposed, with just a letter of recommendation, ask them to either get licensed or do all the business in the registered name. But if that's not the case, if there's truly two separate companies and this is just on paper, they're associated, but then there's no licensed employees at the unregistered company, I would look at it differently.
I can give you some more background on the company if that
Okay.
would help.
Okay.
So I want to say that the licensed company was founded in early, maybe 2000 to 2003. And then that owner started the LLC around 2008 as like an experimental like research and development company. I think that the licensee mainly does like doors and like entrance security, from what I understand. And then this one, the offshoot was kind of like an experimental engineering firm, but they have the same address, like
It might be the same
owners,
employees.
same officers. Like they see it as one. I mean, they have different roles, but they see it as like all one big happy family.
Feel better about that then.
They did come in the office, we did put both entities together. We put it under a DBA. Therefore, all employees, what I understand, would have to, that are working in with this company in this field. They've combined the two by doing the DBA and with the license with us. So that means their registered employees will have to be registered.
We already have a motion, right? So,
Yeah, to concur with council with,
do you have another question?
With the letter of warning but providing clear instructions to them so that they can come into full compliance.
that was the motion.
That may
on
need to be a
Ken.
two-page letter.
I second that motion. No, with the additional explanation, I feel more confident in that.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to concur with our council's recommendation and to include a letter with clear instructions on unlicensed activity. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. So what y'all are saying is if this is one company under one umbrella but two different names, everybody needs to be registered employees, pretty much. And y'all are gonna monitor that too.
If they're setting it up as a DBA, then I think it would be pretty clear.
Okay. Next case.
Number 8, these are represents. You have 2014-024291 and 2014-009181. Background is this complaint was referred to the board by the Attorney General's office. The Metropolitan Nashville Police Department was contacted by an employee of respondent who claimed to be a, quote, whistleblower. He said he was moved by the respondent to Nashville to learn a, quote, takeover technique whereby representatives could contract with customers with existing security contracts and tell them they are there to, quote, upgrade their system and, in actuality, change the system over to the respondent. The board investigators spent a great deal of time trying to locate the whistleblower employee, but were unable to do so. The only violation that the investigation could definitely substantiate was that the respondent had conducted alarm sales activity before they had been properly registered and licensed. The former recommendation was to authorize formal and send a consent order with a civil penalty in the amount of $2,000 for engaging in the business of an alarm system contractor without proper certification in violation of TCA 62-32-304A. The board's decision was to authorize formal and send a consent order with a civil penalty in the amount of $5,000 for engaging in the business of an alarm systems contractor without proper certification in violation of Tennessee Code Annotated 62-32-304A. Updated information is the respondent provided information showing the company had been licensed and provided documentary proof of the date of the employment of the individual and the date of licensure. I'd like to point out to the board that the original licensure date was June 14th, 2013. So the board this company has been properly licensed for, 4 years. This complaint is from 2014. We've had no subsequent complaints. So the new recommendation is to close.
Madam Chairman, I make a motion that we close this particular complaint, but also that we make sure, if necessary by letter, that the respondent company has a copy of the Code of Conduct set out in our rules concerning misrepresentation and this sort of thing, which was alleged in this. So we would be closing the formal hearing and the civil penalty, but I think we need to make sure that this company, and if we need to do that with a letter, making them aware of our code of conduct so that the alleged behavior would not be part of their business model.
When did the board hear this case?
2014, I believe. I'm sorry, I didn't hear you. 2014, I believe.
And it took 3 years for the company to respond to this complaint?
I'm not sure that's the case. I will say I'm not the attorney assigned to this. I think this may be something that was authorized for formal and was reviewed by the assigned attorney and realized they've been licensed for 4 years. The allegation was unlicensed activity.
That's kind of, pardon me, but that's kind of where I got confused. If they were licensed from 6/14 of 2013, my office would have found the license.
That's what I'm
We wouldn't
wondering.
open the 2014 complaint.
Yeah.
Something happened, and I'm not familiar with what happened with it.
Activity occurring before they got licensed?
That's not what it's saying, especially coming from the Attorney General's office.
Was there possibly confusion on the company's name?
There may have been.
I think there's a lot of unanswered questions. Let's postpone this case until August, and that'll give you a couple of months to figure out before we vote on it, that'll give you time to get some more answers.
I would certainly concur with deferring this.
Yes, I believe, Mr. Roberts, didn't you make a motion? We might need to.
But we had no second.
We had no
And
second.
no second. Okay.
I will let that one die. Number 9.
Yep, that's another represent. That is case number 2017-002661. This case arises out of an industry complaint alleging respondent, an unlicensed individual, post advertisements on social media to install CCTV systems. Respondent admits to installing at least 19 CCTV systems that homeowners purchased from retail stores and wanted installed in their homes. Respondent believes that his services do not require licensure because he is installing cameras, not alarms. Previous recommendation was a $1,000 civil penalty with formal charges authorized for violation of TCA 62-32-304A, which is unlicensed activity. The board concurred with that recommendation. Updated information is that respondent visited legal to discuss his case. It appears he genuinely, albeit mistakenly, believed that video equipment installation did not require a license. He signed a consent order with a payment plan. Before he made his first payment, but after signing the consent order, his fiancée informed us that respondent had been seriously injured in a motorcycle accident. The accident resulted in a traumatic brain injury. The family member provided emergency room records. Considering respondent's admission of fault by signing the consent order and his current medical state, I recommend that we close and flag this case.
What is his current medical state? See, we don't have any dates associated with this. If the traumatic brain injury was last week, it'd be one thing, but if it was 2014, then it would.
I received a copy of the medical records. The motorcycle accident occurred, I want to say within the last month.
Yeah, because this is a 2017 case according to the date on it. So.
It was just presented at the last meeting.
Yeah.
I make a motion to concur with the recommendations of our council.
Second.
Okay, we have a motion by Mr. Cockcroft and a second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
I did have now that you've already voted on that, I did have a question. Does this mean that the business closed?
Are you,
Oh, yeah, I'm asking.
yes, I mean, I don't want to reveal he's not working anymore.
Even if he,
Was it his company? Is it closed? Was he working for somebody else?
It wasn't actually a company. This is just a guy advertising on Facebook that he'll install the, camera system you got at Walmart. It was just him. And he came into legal. I explained to him why what he was doing was against the licensing law. He signed the consent order and admitted fault. So, yeah, no comment.
And it does say to close and flag. I would take this to be, he could, if he recovered and he wants to get licensed later, he could do that. But if he continued to do work in the future, if he recovered and then continued to do unlicensed work, that'd be another issue. But right now, and due to his circumstances, we're just.
Not trying to collect.
Just remember, if you don't have a license, I don't have anything to flag. I have nothing in the new computer system won't.
And you can't
unless
enter-
I can remember it when I see it come through.
You can't enter something you can't put in a name.
No, we will not do that.
Okay.
Is that all?
Yes, ma'am.
Thank you. Good report.
Thank you.
Ms. Thomas, do you have anything? Okay.
Not as far as the legal report's concerned, but maybe later.
The next thing on the agenda is our appearance, but would you mind, Madam Chair, if we took like maybe a 5-minute break?
No, we'll take a 10-minute break. The next item on our agenda are the administrative matters, Ms. Best.
We're going to do the appearance. We
You
have
wanna
one
move to the
appearance today.
appearances? Okay.
The gentleman is Adam Jackson. We'd asked for him to come in and come up and sign in. One is to speak. In your packet, there should be Exhibit A, and the name of his company is Edge AI. And he's come before you, wanted to explain his company to you, to see if he actually.
I can't get my iPad out of the legal report, so.
I found if you bang it against the wall
I'm
hard
not
enough.
banging the state's legal iPad against there. Oh, you got it. Thank you.
I did bring some. Marketing packet that when we do start selling our product, that we give to customers.
So this is to determine this gentleman's qualifying agent.
He's asking whether or not his equipment and the service that he's offering, if that is something that requires licensure by the board.
Okay. Give us just 1 second to review the file.
why we're here and in a little bit more detail. So first,
Speak into the mic, please.
we have a small army of attorneys. I decided not to bring them with me today because I've never
There's a button on that thing you can push if it doesn't stay on Vox. Okay. It looks like, very interesting software, what you've got. It looks like it could meet, a need for.
So, yeah, basically, I just wanted to get your guys' opinion on, obviously, you guys are the experts on the matter of whether we do fall under some of the Tennessee statutes as far as being.
What's your business model right now? Do you sell, is this something that you're selling directly to a school system or a school, or are you selling through an integrator?
So right now we aren't selling anything yet until we get a ruling from you guys, but we do plan on probably starting with private schools in the area that already have existing security systems that would be suitable for us to integrate. I think the key factor for us, so when we started looking at who our target market was going to be, started looking at laws in Tennessee and realized that sex offenders are not allowed on school campuses, by the letter of the law, but there are about 15 exceptions to that at any given time they could be on campus legally. And so we're looking at how that applied to the laws over here. And to me,
Do you think your sales will just be local? I mean, is it something you're not, because it seems like something, if you're developing a software or system, I mean, you could be selling this all over the country. It could be, you're almost more of a manufacturer than you
Yes,
could be. And that's one way that you could, if you were just a manufacturer, you're making software and you weren't doing installs, you went through an integrator, then, and you can even go on site with a customer. I mean, there's current manufacturers reps that might sell a Model A camera, Model B camera, that will go out and consult. They'll go with a salesperson from a licensed company. I think the problem that you'll have is when you're installing stuff. When you get into putting in cameras, if you're actually going to install the cameras or maybe even integrate with cameras that are already there, you would probably want to have the experience or the knowledge that the board requires for the install kind of stuff. But if you're just developing software and selling software to integrators, then I think my opinion is you would be excluded under the manufacturer or supplier aspect.
so from our perspective, we don't have any intent to ever install a closed circuit TV system. To be honest with you, our concern with the reason we're not going to a company to cover ourselves is right now our business plan that would add 10 to 15 hours a week to get in compliance and another probably 5 per week to stay in compliance. Back before the board when it's more feasible for us to take on that.
So basically, if a school has a CCTV system, this is coming in after the fact.
Right.
It's an add-on to that system that provides facial recognition to anybody that walks inside that building.
Right, and if they don't have a CCTV system or what 1 or 2 cameras added on, we plan to have a habitual relationship with somebody in the area that's certified. Explain to them how our system works so that they can facilitate that installation.
Do you have any sort of monitoring center or personnel or is the notification electronic? How does it alert somebody when it detects someone that's on the list or shouldn't?
The guts of the notification, how it's happening technically, that's extremely proprietary. But essentially, there is no central monitoring station. Basically, we're only notifying people on site, and typically that would be either a print. Looking at doing some venues, and again, that would just be a security director. That alert comes, it can come via text message, email, local.
That's something that would be automated. It's not there's not personnel staffing a center somewhere to.
Right, and so the way we intend for, and the way we try to educate our customers to use that alert, when that alert comes in, it's a picture of the person in the building and a picture of the person from the database sitting, and they're right next to each other for human verification. And even if that person does determine that they are the same person, it's still not necessarily grounds to have them removed from the building. It may just be that
So who's making the comparison between the person that walks in the school and the database?
so there's our software does that, but just given the state of technology right now, it's not 100%. And so before action's taken, we provide that text message with the two pictures to either a security director, principal, administrator, somebody the school deems responsible enough to make.
So the system is automated that where are you getting your pictures that you're downloading into your database?
That depends on what the schools are asking for. Like most schools want a sex offender registry. That's public data. Most states will give that away freely with the Freedom of Information Act, and it's also publicly available on the internet. And so there's a variety of ways we get it. I don't know if you guys are familiar with scraping algorithms. In some cases we do manual downloads, but there are other. We haven't had custom database requests yet, and so we really haven't gone.
Adam, I would encourage you to become a licensed closed-circuit television installing company. That would certainly eliminate any doubt and complaints and problems and administrative difficulties. We apparently have a bit of a gray area here. If you were a licensed company, then there wouldn't be any gray area. I mean, it would be real clear. I understand that you indicate that you are concerned about having people that would qualify. The administrative burden on being a licensed company, once you become a licensed company, is negligible. A minimal amount of continuing education on the person that is your qualified agent. Registering your employees, which consists of a fingerprint and background check, is not a substantial burden. So I would encourage you to do that. In order to facilitate that, I would question: do you have someone, excuse me, that's a part of your team or staff that could conceivably meet the requirements of being a qualified agent? Someone that has been installing alarm systems, closed-circuit television for some period of time, someone that has perhaps a degree. There are a number of paths in which a person could become a qualified agent. Do you have someone that might meet those requirements?
So we don't have anybody that meets the requirements as they're spelled out in the statute. I've done CCTV systems at U.S. facilities overseas. I've consulted on and then our chief technology officer has a master's degree from Carnegie Mellon.
The board has some modest latitude in interpreting the requirements that are set out in the statutes, and we've done so in the past, accepting degrees, accepting experience statements. The board has some latitude in doing that. but again, not knowing the background of you and your other associates, obviously I couldn't make a judgment call on that.
I
But-
feel very confident, though, that you could, you or someone could meet the experience requirements. Then it's just a matter of a course and a test. And I don't think you would have any problem with that. How many employees?
Right now, it's just the 3 guys that started the company.
Well, reading Eric's bio, I don't know what all his, specific experience is, but he looks like a good candidate.
Eric doesn't have any experience as far as camera systems and things like. He's currently located in
They
Well, it's not. I thought you had to be located within a certain distance. The QA had to be within a certain distance of the office.
fortunately, we threw that out.
Okay.
Ooh, yeah, that was.
But I think that you would,
bummer.
you probably have the or the experience requirements
Yeah,
from what you just described. I mean, it might be a matter of years, but I don't think that's going to be a big hurdle for you. In really the ongoing is not. It is not that. I have a company that's 3 people, and that's so. I mean, I deal with that on the personally. I just went and renewed 2 people during our break, but.
Sure, and when we finish the development of the product and we aren't, so right now we have what we consider a minimum viable product. If we get approval today, we're going to go out and start selling. Absolutely plan on doing the 24 hours of initial certification course, taking the test, and seeing if you guys will approve me as a qualified agent, or bringing Eric from San Francisco out here and right now, I don't know. We would have to significantly delay. We would have to delay what we're trying to happen. And so, my initial course was to stand in front of you guys and figure out if we are an alarm company, if we subcontract out a lot of the CCTV, or all of the CCTV stuff.
Are you operational in other states?
We are doing initial sales in other states. We haven't, and we have 2 beta. Haven't accepted money for a product yet until we figure out how everything's going to go. Not necessarily. That's the only thing we've done with the beta test, but we would do, if somebody wanted a custom database, there are ways to facilitate.
I can ask you, and would your company be the installer of the camera?
Like I say, Adam, it's really kind of a gray area for us. You're sort of doing stuff that our statute is intended to cover, and yet you're sort of doing some stuff that is outside of what the statute clearly identifies. It really is a gray area. But like I said, I would encourage you strongly to go ahead, jump through the few hoops that it would take to become a licensed alarm company, and then there wouldn't be any questions. You don't want to be up here 6 months from now where some other alarm company has complained that your company has been doing things that require licensing, and then we've got a complaint filed, and you got legal people and more attorneys, and then you're back up here trying to come up with an explanation. I would encourage you to do that. I think it would be a wise move strategically on your part. And aside from I suspect you could meet the experience and requirements in terms of be one of you becoming a qualified agent. I suspect you would be able to do that without a great deal of trouble, and I would encourage you to do that.
So the only classification we're looking at is
CCTV, yeah, sure. I guess that's the best advice I can give you. I mean, you've come honestly trying to present your case and get a clarification, and that was a good thing. I would encourage you to take the next step. Go ahead and become licensed. That way you've erased all doubt.
Based on what you guys see in the packet in front of you, as long as we don't try to install any CCTV cameras, it was a complaint that would cause us to, wind up with a fine or anything like that.
Main thing that I would see is because you mentioned subcontracting, you can't sell it and then sub it out to, you couldn't sell a camera system. Say you sold a whole package that was your software and the camera system, and you bill the school for that, and then you pay because you're engaging in the alarm activity. If you sell the school your software, or you sell it to the camera company, but the camera company has to be the one dealing directly with the school for what they're doing. That would be my opinion.
So I've actually watched one of your videos in preparation to come here, and actually saw a case like what you were talking about. So we changed our model a little bit. We would go around, we would tell this, we're only going to sell software and a piece of hardware to the school, and say, ideally for our system, a camera would go here. We're not qualified to make that judgment, but we do have a habitual relationship with this company, and they understand how our system works. That's who we recommend. And I think that was actually the board's recommendation, I think, to the case that I watched.
There was something similar probably that was the panic buttons and courthouses or something that.
If we go that route, are we in any gray area as far as the statute of the board's concerned?
I think that would make it much more clear. If you sell into the XYZ alarm company, you're selling them your product, they're installing it, then you would fall in the category of a manufacturer and not be required to be licensed. And that way you would understand it. I think it would be the case. If you're selling it to the school system and somebody else is installing it, then you're acting as a advising and consulting with the school system, and that falls back under the statute. So you're back into that real gray area again, kind of a dark gray under that scenario.
So if we sell specifically basically a computer that has our software on it, and that's all to the school, we configure that computer, and that's our only interaction with the school, other than maybe recommending a CCTV installer.
You could certainly recommend a CCTV installer, and that wouldn't be a problem, because then they're actually doing the sales and installation. If you're programming a computer and furnishing that, and especially if it goes through the company that's installing whatever cameras or such might be necessary, then I think you would fall under the manufacturer's exemption. But on the other hand, if you're there on site with the at the school, and you're talking to the principal of the school and saying, "Hey, we can sell you this," and back into what's pretty clearly a gray area. Okay. So and that was the reason I made my original recommendation. If you had a license, then
there's no question.
Then there's no question.
It's clean as possible.
I guess
the attorney's got a
sure.
Would it be helpful if I read a couple statutes into the record?
If they apply.
Yeah. That's the goal, right? So you've got just a couple issues when you're talking 6232-304, which is prohibited activities. You've got, I just lost it. You've got K, no person shall advise anyone as to the need, quantity, or quality of alarm systems and sell the systems unless certified, licensed, or registered under this part. And then you've also got that no alarm system contractor may participate in a joint venture to provide equipment or services that require certification under this part unless all parties to the joint venture are certified in accordance with this part.
I guess my question to you is, when does a habitual relationship of, hey, we know these guys really well and we trust them to do good work for a customer that we may, when does that relationship become a joint venture in the opinion, or I guess as this statute is concerned?
No, there really wouldn't be a joint venture. If you're selling to XYZ Alarm Company, your computer programmed software, then they are the registered alarm company doing the installation. That would not be a joint venture. You're selling them a product.
So at this time, we have no intention at all to sell our computer and software to an alarm company or to license that for sale later. We plan to do direct sales of our hardware and software to the school, and then integrate into an existing camera system, or have a subcontract, or not a subcontractor, have a licensed CCTV installer come in and assess their cameras and install cameras as needed.
I'm sorry, and Mr. Jackson, just correct me if I'm wrong. I think the basic question that brought you before the board today is whether or not your system itself even constitutes an alarm system, because it sounds like from your conversation with the board, you sell more software that is incorporated into existing alarm systems. Is that correct?
Right, and we don't have any intent to act as an alarm company. We don't want to replace existing alarm systems. It's just something to provide situational awareness to.
To me, it's like a non-alarm add-on to an existing system.
I think that goes to the gray area that Mr. Roberts mentioned, because on its face, it's not seeming like an alarm system. I think the board is just trying to would fall under that definition, because if it does, then that goes into what Ms. Shepherd was explaining as far as the prohibited activities.
Well, the system is clearly part of a closed-circuit TV system. I mean, without closed-circuit TV, it's not going to work. Mm-hmm. So it's part of a closed-circuit TV system. It interacts. It sets up an alert condition. I think it pretty clearly in that regard would fall under being required licensing. Like I said, unless it was sold through unless you're putting, what you indicate, you're going to sell it to the schools, and that's what you want to do. You don't want to try and get some licensed alarm company to go out and represent your product to the school. You want to sell it to the schools. I mean, that would be an intelligent business plan. And I think in order to do that, you really should be a licensed company.
I guess my question is, you say that I guess I don't understand how we become part of a closed-circuit TV system by just taking in that video feed. By that, if I sold a TV to a school that displayed that feed, I would also need to be a licensed alarm contractor.
Well, and there again, it would be a gray area, but where that would get into an issue. I mean, if you just sell someone a TV, they come buy it, and then they take it and install it and hook it to their CCTV system. You just sold them a TV. The difference is, if you sell them a TV with installation on a camera system, then you're working on a camera system, and that may seem silly, but if you then take that TV to the site and plug it in, and you're interconnecting it to the camera system, then you have, in that case, someone selling a TV and replace the monitor on a CCTV system would need to be licensed. And the difference is the installation aspect of it. And on your system, you could sell the school board the computer and ship it to them, and you're just selling them a computer with software on it. But when you show up at the site and hook it up into a camera system, because you've got to do something to integrate it to the camera system, you're going to have to get in and do work on the camera system, even if you didn't have to physically do anything. But you also may show up somewhere and it's like, well, you've got to run a wire for this new computer. You've got, even if it's just a network cable, you're doing some interconnecting, and it's really when you get into doing wiring or any kind of installation and on site. If you never set foot on the site, I don't necessarily see that as installing or.
If you're not on site at any point, then you're not doing, you're not involved in alarm installation work.
I think your marketplace, not that you're here for business advice, but your marketplace could be so much bigger than. It seems like you're talking about just a few customers here, and you may be selling this everywhere. And why would you want to limit yourself to? Why would you want to do the installs? You've got something that's so much bigger than that.
So we plan on using Nashville as a beta test bed. between our CTO and myself, we have the ability, if something on the system malfunctions, we can identify the problem and build a model for less technically skilled installers to possibly do this down the road. So you mentioned that I'm actually working on the security system. So a prerequisite for us to step into a school is there has to be a way that they're distributing a video feed. So we're actually not even touching the actual XVRs or DVRs or MVRs themselves.
You're just picking up the stream.
Right. So, and I don't know if basically we're picking up the RTSP feed and putting that into our software. So we're actually not even integrating in any way, shape, or form into the camera system.
Did you do all of your work remotely? You know, like a
Yeah. So if they gave us internet access, yeah, we could do it. And so to me, like that seems like a almost arbitrary point that if I sit at my house behind my keyboard and configure the computer, I'm good.
Well, you're the one looking for a loophole. I'm
honestly,
I agree with you. That might be silly, but I'm trying to help you find one in some ways. It all gets back to the cleanest would be get licensed. And
absolutely, but I mean, I know I assume well, I guess I shouldn't make assumptions, but anybody that has started a business in an early phase, 24 hours and waiting 60 more days to have my hearing on whether I can be a QA, and then after I have that hearing, getting qualified again, that's 4 months.
None of this is stopping you from, definitely you developing software and you designing something. You don't have to be licensed to do that. You can create something, have your business in Tennessee and go install them somewhere else. I don't think if he's not, it's about him doing installation and sales in Tennessee. You mentioned something about you could go to Atlanta. Well, you can have your business here and install in Atlanta if you want to. I mean, I don't know what Atlanta's licensing is. I think you probably would have licensing there too, but.
And again, as the only installer in the area, I'd have to move. We'd have to move everything to Atlanta at that point.
And I go back to why, with your knowledge and your experience, why would you want to do the camera install? It sounds like you're technically so far above that. Why not?
Scott, he's starting a business.
Yeah.
I mean, you know, he's
partner with somebody in Nashville that you're going to sell them. You would have to sell through them. You know, you would have to be a manufacturer, sell them the software. I mean, you'd have to be selling something to the alarm company. Let them sell it. And
it's a 3-man company. I mean, he's working out of his basement or whatever. And hey, I started that way. I mean, I understand fully where he's coming from.
How would you feel from the standpoint of if he does want to do beta testing, that he's not going to sell anything, or is granting him some exclusion just for him to do beta testing with some limited number of sites? Or
I don't think we have any latitude to do that. I really think, Adam, you need to be licensed.
He wouldn't be selling if he's not.
Understand where you're coming from. I think you got a great product, a strong concept, and I think you're developing a good business model. But I think that in order to avoid unnecessary complications, you really ought to be a licensed company.
What part of our system is the trigger point that says we need to be licensed?
On-site work. If you're going on-site and selling it to a school, then you need to be licensed. If you're going on-site, if you're connecting into the alarm system, if you're installing, I say alarm system, CCTV system, if you're installing cameras, which you may or may not do, then you need to be licensed.
So I guess from what you said, we don't plan on installing any type of camera, so it's purely the on-site aspect. So if we set up a VPN, hand the box to the school, and I do all the stuff from my house, at that point, are we good?
I think you'd probably be good at that point. We're trying to be sympathetic here. But
I appreciate it. It's one of those things at this point, like, anyway, yeah. Okay. If we were able to pull an RTSP feed over a LAN network from their system and not touch a DVR.
If they're doing it If you've got an on-site, if they've got a school technician that's making the connections, plugging it up, you're working over the internet, you're not on site to market the product, sell the product, install the product, or related products, then I think you're clear.
We can't sell the product either.
You're on site selling the product as part of a CCTV system. I think you're required to be licensed.
So, like, to be completely clear, we can't keep our business in the state of Tennessee.
Getting licensed is not that burdensome.
It's not necessarily burdensome. It's a timeline. So we're from today to license is a minimum of 4 months with having to get an exception. So we're ready to launch today. We can't do so. We don't have 4 months to wait.
How do you determine that 4-month timeline?
So because we don't have anybody that by the letter of the law meets the certification, we'd have to go through the process of getting a QA all set up, get the application done, come to the board, ask for the exemption, and then
Talking 60 days. We meet again in August.
so it's my understanding that in 60 days we'd bring the person we plan on getting approved. The board would give their blessing, and then the next meeting is when that person would be able to be approved.
You could have someone
And-
start taking a test today or taking a class and
You're
taking
adding
tests.
2 extra months on there that I'm not
Actually,
understanding.
all he has to do is get an independent qualifying agent. He just needs a qualifying agent. He just
That's
needs to
it.
hire somebody to do it.
We're
That's all he needs.
we're completely self-funded. That's absolutely not an option right now either for us. So, just from a business, a business perspective from us, we have,
You sound impatient.
absolutely, sir, absolutely.
And I would say that if it's that financially burdensome to get to get licensed is not that expensive. There's not that much. We're not talking about that much expense. If that's financially burdensome, then I would be concerned, and we shouldn't allow you to be doing business in the state of Tennessee. If the cost of the license in the state of Tennessee is too burdensome, then your company's not financial. And I'm not saying I don't think this is the case. But if that were the case, your company wouldn't be financially stable enough to be in business in Tennessee.
Well, I think it's part of it too. You're going to have to physically move somebody to Tennessee. Is that part of what you're?
lives here, don't you?
So I live here.
He lives
Yeah, I do.
here.
I live in Robertson County.
Yeah.
Well,
It's not
then
a problem.
Yeah,
So
I was wrong then.
The other, it's not necessarily an issue of money; it's an issue of time for us. And I keep going back to from my perspective, being able to work on this system over the internet and have my keystrokes go across a wire instead of my keystroke be in front of the computer. I don't understand. I'd ask for a legal opinion on that.
Well,
If you're not on site, then and don't go on site for sales, installation, service, or technical advice, any of that, then you probably wouldn't have to be licensed.
I'm honestly trying to help you. I'm trying to think of ways you can do it. And I'm trying to compare it to other things that, I put in camera systems and I put in alarm systems. And I'm trying to think of relationships that I have with vendors. Like I buy cameras from a particular company and they'll send someone out to help me, or they even remote in and they don't have to be licensed. And I guess I'm trying to see you as, I'm trying to think of, okay, well, supplier A that's in California that helps me install a camera system, he doesn't have to be licensed. And he might remote in to work on a system for me. But, and he's a manufacturer, and manufacturers are clearly exempt. And if you were in that category, and that's where I'm talking about remoting in from that standpoint, you could, but that's where we're getting back to the whole gray area of, it gets back to being licensed. If you're licensed, there's no gray area. Nothing's preventing you from continuing on. You've asked our opinion. We've given you our opinion. You can still go out and not comply, and someone may turn you in, and we may be back here. But we're just trying to be honest and tell you. And you may even get, you might even have a different board up here. I mean, we may not be the same people when you come back. You might get a different answer. We're just, I'm truly trying to help you. I'm trying to just give you that's one clear way to me that you could just be you might have to change your business model for 6 months and say that you're going to sell through an alarm company, and you find you an alarm company and they sell the stuff. I mean, I don't know, or maybe you've already sold some that you need to put in. I don't know what the rush is, but
Rush is I don't have an income right now because I'm starting a business. So
When you're doing a startup, I mean, you're desperate for pennies and nickels, really. I've been involved in that.
and I get
fully
that. I understand that. Yeah.
So I guess from the last question I'll ask the board, and then I'll thank you guys for your time. Looking at our system, if we're pulling an RTSP feed, to me, we're not integrating into a camera system. Is there anything else about our system? What else about our system in the
Sales.
But if we're not selling, if we're only selling our box and our software, we're pulling the RTSP feed into the box. To me, that's not integrating into the camera system. The board, if you guys have a different opinion on that, I'd like to,
Well, would you say that somebody that installs a camera and it has a feed coming out of it, and someone else puts in a DVR, that they aren't integrating the two together?
Sure. A DVR, if you were recording that video to be reviewed as part of an alarm system, yes. We're actually not keeping any footage whatsoever. It leaves our system as soon as it's evaluated. And so, to me, that's about the equivalent of a security director remoting in to look at the feed.
But the security director's doing his own work. He doesn't have to be licensed.
Correct.
If you worked for the school board, you could do it. If you were an employee of the school board, you could.
I guess to boil my question down to a fine point, what part of our system, in the opinion of the board, makes it an alarm system?
Well, you're detecting an alert condition or a potential alarm condition and sending a signal back to the premises or to a responsible individual. I mean, that I would think is pretty clearly an alarm system.
So, and again, like I didn't bring lawyers because I didn't want to get this down into the weeds. As far as detecting an emergency, our system specifically, we are not.
Oh, you talk about getting lawyers involved. Lawyers, if you brought some lawyers with you today, you'd have spent more than you would spend on getting licensed. Why are we talking about this?
Again, sir, it's not an issue of dollars. It's an issue of time.
But you could have already applied, and you probably could have had a license. But anyway, I'm sympathetic, but I'm kind of losing. I'm losing you here. You're not going to change our mind from the standpoint of we're convinced that integrating it makes it part of the system. We didn't write the law. We're trying to hold it, interpret it. I mean, if I could find an exception for you, I'd find it, because I'm truly trying to help you from that standpoint. But I think you're pushing it, and there's only so much we can do. We can't change it or make. We didn't make the law, so the lawyer stuff isn't for us anyway. That's
sure. And to be honest, before today, I didn't know it was a better route for us to go would have been to go to the legal office and have this discussion. I actually didn't know that was an option. So in that sense, I do apologize for the board.
I don't mind hearing it. I mean,
sure.
I think you've got a great product. I think you'll do well with it. There's a few hoops to jump through here, but.
And again, I'll thank you for your time after this. What portion of our system makes it the alarm system in the opinion of the board?
How about I read out the definition of alarm system, and maybe y'all can pick out which sub part of that definition it fits under too. 6232-3031.
Have that on the iPads.
Sorry about this. I'm just reading the statute too. Yeah.
Okay.
Alarm system means any mechanical, electrical, or electronic system or any combination of those systems designed to. So it's an A, B, or C. A, record, view, monitor, protect against, avoid, or reduce the probability of personal or property loss or injury resulting from fire, smoke, heat, burglary, theft, shoplifting, pilferage, or other losses of that type. B, monitor, detect, or prevent intrusion. Or C, detect and summon aid for other emergencies.
You fall into all three of those, honestly, and it's any one of them, right? I think A, B, and C. You detect and summon aid for other emergencies. You monitor and detect.
It has the ability
Yeah.
for that to be done, is what we're saying.
The response that we're trying to elicit is send someone to talk to an individual. The response that's being sent is not to the level of an emergency response. I guess what I'm trying to say is if you had
Are you going to mail them a report at the end of the month, or are you going to send it to them right when it happens?
we're sending it to them right when it happens, but
I consider that it would be more urgent than.
I mean, again, that's not that different than a bell on a door to send somebody out to.
Mr. Jackson, I appreciate you coming before the board, but you talk about your team of lawyers. I think you need to get your team of lawyers and talk to our team of lawyers, and then whatever y'all work out, we'll go from there. If our attorneys recommend us to, at the next board meeting, we'll review your qualifications, we'll do it, but divining and splitting hairs today
We
is not
want
going
you
to
to-
change our mind.
We want you to be in business, and we've tried to explain them. I think we've given you two good options that I could think of anyway. One's get licensed, one is be a wholesaler, be a manufacturer.
And just in short, just to clarify, the board's decision is that your system does meet the definition of an alarm system that will require.
Or he becomes a manufacturer.
Thank you for coming, though. We do
Ad-
appreciate
Adam,
you.
let me suggest that our attorney there indicated paragraph 1 under definitions, which defined alarm system. You also need to look very, very closely at subparagraph 2 there, which defines alarm systems contractor, which means any person, firm, association, or corporation that sells or attempts to sell, install services, or monitors alarm systems, signal devices, fire alarms, burglar alarms, television cameras, or still camera used to detect fire, burglary, breaking, and or entering, intrusion, shoplifting, pilferage, or theft.
And it's
they
got
need to
simply
take
entering
knowledge of
in.
that.
It has simply entering is one of the choices.
Did you get the TCA on that? 6232-303, paragraph 2 is the last one they read out.
And I apologize for any annoyance.
It's okay.
It's
just
okay.
It's not gonna come to any other resolve other than what we've already told you. So, if you have legal questions, we have two of the best in the industry that represent and advise us. So you need to reach out to them on legal aspects.
Sure, and again, I apologize. This was I should have reached out to them first and then.
That's okay.
talked to you
That's
guys.
okay. Thank you.
Thank you for your time.
Sure. Thanks for coming.
And I guess we annoy people too.
I'm sure we do. Okay, that's up to y'all. Does anybody in here want to take a break? Raise your hand, say aye. I guess we're moving forward unless you want to. Okay.
Yeah, that's fine. Now we can go down to the administrative matters, which you have on your iPads. You have the monthly report. I believe this stuff was sent out to him, wasn't it?
Not the monthly, oh, yes, it was.
Okay. And I'll just go over your part here, the alarm systems. We have two members, Karen Jones, Mackenzie Roberts, that their terms expired in 15, and we do appreciate our board members can serve until they've been reappointed, if they can be, or another individual is appointed. You see, we do have our normal meetings with the staff attorney and our normal meetings with administration. For that, that's normal. The next that we do, of course, if you have any questions, please ask me. The next thing we're going to go into is our budget review. I'm always like a month behind on that. We have a ending balance of $399,746 as of the end of. Can you hear me? All right, thank you. It just cuts. If you don't have any questions about that, we'll just go to the legislative update. And I think we did this did we not do that last month? Well, effective January the 1st, 2018, Senate Bill 589 will be effective. It affects Title 62, Chapter 32, Part 3 is amended by adding the following language as a new section. An owner of residential property which serves as the owner's primary residence may cancel a contract between the owner and an alarm systems contractor for the provisions of alarm system services when the term of the contract is for a period longer than 2 years by giving a 30-day notice to the alarm systems contractor after the initial 2 years in the term if the owner is required to sell the real property due to medical reasons.
I think the only thing to add to what Cody read out is that the owner does have to provide the alarm system contractor with a letter from the owner's treating physician verifying the medical reasons. That's Public Chapter 209. And I think that the law reads pretty clearly to me, but if the board feels that we need further clarification, that would be done via a rulemaking.
I think it's pretty clear what their intent is.
Well, I did have some questions about that.
Go ahead.
Okay, so I've got it for 5 years, and I get sick 9 months into the contract. I still have to pay the contract.
It says after 2 years.
But if you're the way I would take that, if you're 9 months into it, you would still be obligated for the rest
The
of
whole
the 20
contract, for the whole contract,
Oh, you think the whole contract, if it's,
isn't it?
You can ask for it to be canceled after you've passed that 2 years.
After you pass the 2 years, but you're still, you're still responsible for the 5 years if you don't get an exemption from them or if they don't accept it.
Right. So to Cody's example, if the person 9 months and they have to sell their house, they're still responsible up for the contract up until the 2 years. At 2 years, you can then ask them to cancel the contract.
That's how I understood
that's how I
it.
read it. But
Yeah.
I had a little problem with that because if I get sick in 9 months and I'm placed in an institution or whatever, a hospital, I'm not going to be going back to my home and I'm not capable of doing anything, you going to take my money for up to the 2 years?
yeah,
We're going to put a lien on your house and foreclose it and throw you out. You'll have to move your hospital bed out in the front yard.
Well, she's not there, so we can't throw her out.
That's
She's
right, I'm not at home.
incapacitated
Oh, well, I guess we
somewhere
got a
else, so-
problem there then, don't we?
That's not to say that somebody can't, they don't have to do this. I mean, the alarm company can make the decision, and they do that all the time anyway. Like a lot of companies will, it may not be 3 years or whatever, and they can choose to not enforce
Yeah,
even
I just
beyond
thought
that.
it read odd.
The reason that it's that way, though, that if they said that a medical condition could just exempt you altogether from the contract, it would make it hard for alarm companies to do business from the standpoint of. But it's also fairly open for what a medical condition is. I mean, I think it was intended to be something serious. It might even be that a diabetic had a foot amputated and all their bedrooms in that house are upstairs. Maybe they can't. Maybe they can't stay there. That could be a medical reason. It also might be something more serious. But it's also pretty vague. It could be that It could be a psychologically medical, that all of a sudden you don't like your neighbors next door. I mean, this could be taken way far.
Well, how common
but
is
it's-
it in the industry
but
to
what-
have a
It's not that-
monitoring contract that extends that many years?
Well, we had one before us earlier that was a
Right,
5-year
that was
contract.
5 years,
Yeah.
but I mean,
Most nowadays are either 3 or 5. I think that's fairly common. And the issue is with someone that's installing a system for very low cost or no cost. They may put money. It may take them over 2 years to recoup the cost of the system. I mean, someone that's installing an alarm system for $99, they spent $1,000. The alarm company spent $1,000 probably selling it and buying the parts and the labor and everything else. So even at 2 years, they may not make money on it. And that's just like, it may seem cold and hard from the standpoint of view where, you had to move, but the mortgage company's going to want to get paid on the house too. I mean, they're not just going to say, well, there's other things that you would have to pay. Also, hopefully selling the house would help you recoup some of the money. But the alarm was a fixture or an asset that was on the house that ends up getting sold. So hopefully they recover some of that, and the alarm company can make the choice to which I would imagine most small alarm companies, if you knew the circumstances and something happened, they're not going to pursue it. But I don't think we could write a law that would be so. I think it would be bad business to write a law that was so extreme that said, well, you could get out of the contract for any reason. I don't know. That's just my opinion, but.
well, I mean, the same could apply to cable, direct, satellite. If you enter into a contract for so many years of service, I think they've done an exception to allow somebody out of monitoring. I don't know if there's an exception for other utility providers or not, that if there's a medical that you can get out of a contract.
Well, they've got to sell the house too. If they're forced to sell
true.
the house, I mean, you're not going to sell your house because you get athlete's foot or something.
It's at least better than this. This is better than nothing. I mean, before this, if somebody had a 5-year contract, some company that isn't compassionate could have enforced that whole 5-year contract. At least this is limiting it to the 2 years.
Mm-hmm.
It's an improvement. It may not.
Oh, no, thank you. I appreciate it.
Well, it's kind of fair to everybody because you're not letting,
Not letting them out totally, but you're also not enforcing the whole contract.
Well, just as a point of information, I don't know what the numbers are now, but I know in times past, major alarm company that was involved in selling a low cost or no cost system, their break-even point was 30 months. So, as Scott said, I think the statute or the addition to the statute that's being written is basically fair for all concerned. I think it's a pretty reasonable piece of legislation.
Well, thank you. If I get asked that question, I can explain it a little bit better. Thank you.
Okay. Next, application review.
Yes, that's also under me, and these are going to be a little different. We only have 2. Because I don't normally do this, but their record is so extensive. It is after 10 years, which you told me I could approve, but we have this first individual that you're going to be looking at. Exhibit A had a 1987 burglary where he got 2 years, 1989 theft where he got a couple of years, and there are other charges as well, and I did give you a copy of the report. You will notice on the report I have made a little square box, and what I found was something that you need to be aware of. 14 of 1990, for instance, he got 8 years, but looks like it was 5 years suspended sentence. So I just want to give you a few minutes to look. Trying to be a registered employee. So you have the criminal record, and you do have the documentation that goes with those records. You might have a letter of explanation I didn't go that far with it before letting you look at it.
How many of these are felonies? Can you tell from the?
Any of them that says they got got a year or longer is a felony. And some of them on there is,
Can you approve something yourself if it's felonies that are over 10, or is I thought it was some of it was misdemeanor stuff, but it's
give me the authority to approve anything over
Over
10
10.
years. But I was not comfortable doing this one, so that's why I brought it to you.
Here you go. Once again, exhibiting extraordinary wisdom.
that's right. That's right. I have two thoughts on this. One is, I know we're not supposed to consider what the position's for, but it looks like it's for fire protection. But I don't feel comfortable approving this application at face value, because we could ask the person to come see us. We'd probably approve them if they did and talk to us nice, but just thinking out loud.
Is that a motion?
I don't usually make motions. Ken makes all the motions and I second everything, but
For the record, I believe that you have made motions.
I've made a few. Yeah, I've made one today, I think, maybe. All right. Well, I would make a motion that we deny this application. Well, we don't want to deny it. We want to just ask them to come before the board
No, I think we want to deny it, and then they can come before the
if they want
board.
to.
They want
They
to
could
appeal
appeal
They
it.
want to appeal
I
it.
make a motion to deny this applicant's registration.
Second.
We have a motion by Mr. Cockcroft and a second by Mr. Roberts to deny this application based on poor moral character. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Thank you. Now you can go to Exhibit B, and we're looking at the record as well. Also make an application to be a registered employee. Have the record in front of you. You do have the in documentation. For the record, we do have, looks like we have 1982 charges where larceny and possession of marijuana. 2003, theft in the 5th degree, was found guilty. Breaking and entering.
Cody, you don't ever, you approve some if they're older than 10, but you don't ever deny anything that we don't. Basically, if you question it, we see it, right? So you either approve it or send it to us.
No, there are times I can look at a criminal record and go ahead and approve it. It might be something as simple as driving, maybe one DUI.
That's what I was saying.
or
You
something
either
of that nature.
you'd
but
approve it. You either approve it or send it to us.
right, that's the way I do. Yes.
It's nothing that's so
If I feel it's egregious, yes, you're going to hear it.
okay. Y'all had time to look it over. I'd make a motion to deny applicant B.
Second.
We have a motion by Mr. Cockcroft and a second by Mr. Roberts to deny this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
All right, thank you. Next thing on the agenda is the request for an extension, but we do not have one. We just kept that on the agenda. Application review, we also we just included the criminal history. Now we're down to the education report. I believe what we did. You didn't get anything, Scott?
No, ma'am.
No, that's because we sent them to Keith, who's
Oh.
did send several to Mr. Roberts. We can go ahead and do those if you're ready.
Two, as I recall, I believe I have both of those with me. One was a course by CenturyNet Inc. entitled Beyond the Signal. It was for 2 hours of continuing education. I felt like that it was appropriate. The other was a course provider, Alarm.com Inc. Their course title was Alarm.com Smart Thermostat Installation 201. It also requested 1 hour of continuing education, which I would recommend. So I would recommend these two courses. I'll make a motion that we approve these two courses as they have been requested.
All right, may I ask a question before we take that motion? I do have the thermostat installation 201. You also had automation. Are we saying all that course, which is a 7-hour course, the whole thing? You had automation and energy 201, installation tools, interactive services.
Never saw those.
They never went through?
I never saw them. I printed out what I had, and I only had these two.
Well, alarm.com, it is the second one, but it had several things
There's
attached.
several
It was
courses.
they all wanted continuing education for 1 hour each, and it was 7 hours.
Oh, 7 courses, each requesting 1 hour of continuing
yeah, for the
education.
program,
I
yes.
did not see those. They did not print out for some reason, but they courses of that nature for a 1 hour continuing education would seem certainly appropriate, and I would include that in my motion then.
Okay, we have a motion by Mr. Roberts to approve all of these education courses as listed for continuing education. Do we have a second?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, thank you. Have to send this out. I'm going to have to send this out to one of the Bedrock Learning Incorporated. I don't know when they wanted this course approved. There are various courses, there are various hours or whatever, but they'll have to wait till the next.
Do you have any of those printed out, or?
Yes, I
With-
do. If you had someone, if you wanted to review those. Second here, and I believe I've got them right here for you. I got them.
Several Bedrock and then one Jade. and then we approved everything. Does Bedrock had stuff before? Are they new? Horses or was it actually on here? Okay.
We went ahead, no, she went ahead and loaded them.
Keep wanting to play music.
Like paper if you.
I know what you mean, there it is.
Me too.
There might be more than you want right there.
That's Jade. That's the,
Why don't we take a 10-minute break or something like that, and
I think,
take a quick look
you
at
think
these?
y'all, will 10 minutes be enough? You want to take 20 just to make sure?
Whatever.
We're going to take a 20-minute break. I think the next thing we need to address are the courses, the Bedrock and Jade that Mr. Cockcroft and Mr. Roberts reviewed during the break.
Yes, ma'am.
he took the time and reviewed both of them or all of the courses, and I would make a motion to approve both the Bedrock and Jade courses for continuing education.
Second.
Okay, we have a motion by Mr. Cockcroft and a second by Mr. Roberts to approve the Bedrock and Jade courses for CEU as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Then the new business?
Yes, we just have one thing I wanted to bring up. We did get the invitation for the TNESA convention that is going to be in Franklin to speak for 2 hours for continuing education. That is the day before we will be having a board meeting for our private investigation commission, so I will not be attending, nor our attorney. So, I should say. So Mark Amick will be going to that convention. Whoever else he chooses to take with him, because it will be the presentation probably, I'm going to say it is, on the onboarding. And one other thing is, Sean and I are trying to get together the last outreach that we're going to do for the year in Pigeon Forge on the new computer system and changes that we have in the office. Any problems that you may be experiencing at the time. The private protective services encompasses the alarm contractors board, locksmith program, private investigation and polygraph, and private protective services. Everyone will be receiving an invitation to that seminar. It will be held, we think, at the Music City Center in Pigeon Forge. Large facility. It's where the TBI meets, and it's 500 people. I can't imagine we'd have more than that. We want, boy, that's what we will be doing. So you have the last opportunity to get your office personnel there, whoever that is going to be doing your onboarding for your registered employees. Everyone now must make new application or renew online.
I know you don't
Working
like
on-
video, but it would be good if you could.
I think
It would be good if you could video that, if that's the last one, or have
yes,
you
we
videoed some
will.
of
We
them?
will be doing that. They will be doing the whole news media thing, and it'll be recorded probably. We do have the PowerPoint anytime you want a copy of the PowerPoint, if it would help. Mark will be doing whenever he goes to the alarm convention, but I just want to make you aware that we are going to have one.
And you don't have the date set for that one yet.
We're looking at the 17th and 18th.
Waiting to get the information back from the hotel.
And it's going to be the same class at the TNESA?
Somewhat, yes. Well, it'll be
It
geared just for
abbreviated?
the alarm board there when you do that.
Okay.
Our little, we call it our outreach, is always a little different because we go over the different things that happen in the office. the different paperwork or what may be coming. It's a whole lot of fun.
That's been well received in the past.
Oh, yes. Madam Chair, I do believe that is going to finish up anything under my.
Anybody else have anything? Do we have any old business we need to bring up? Okay, if not, this meeting is adjourned.